So I will introduce Dr. Luke Beck. Is a professor of constitutional law at Monash University. He's a leading scholar in the field of separation of religion and government. Gosh, the separation of the powers, something sadly neglected these days, and religious freedom under the Australian Constitution. Please welcome Luke.
Thank you, everybody. Thank you to my fellow panel members. I've got some slides. I don't know if they're going to work or not. Oh, here we are. So start with a plug for my book, where there's a 20% discount code. I'm going to tell you a story about the background to our constitution and the vision of other people for secularism in Australia. And it's not about atheists. It's about religious people who wanted secularism in the Australian constitution. So, in the 1800s, Australia inherited a whole bunch of ridiculous, archaic British laws, including the Sunday Observance Act of 1677, which made it a crime to work on a Sunday. Basically, everybody broke this law. The worst offender was the government. Government railway services ran on Sundays. That was a crime. Sunday newspaper editions were published. That was a crime. The law was not enforced. Basically, everybody thought it was stupid. Except for some Protestant church leaders. They were quite particular that Sunday laws were a good thing and ought to be enforced. Government didn't really think so. But occasionally, the law was enforced against unpopular minorities, including Seventh-day Adventists, who at the time were only about a couple of thousand people across Australia. And the problem with the Seventh-day Adventists from the point of view of mainstream Protestants was that they took Saturday rather than Sunday as the Sabbath. And not only that, they insisted on working on Sundays, which the Protestant church leaders, not ordinary Protestant, but the church leaders found quite offensive. And a delegation of Protestant church leaders went off to the New South Wales Premier complaining about the mass breaking of the Sunday closing laws. So to shut up the Protestant church leaders, the Premier had some police go arrest a bunch of Seventh-day Adventists for working on the Sabbath. Not the government railways didn't get prosecuted, just some unpopular minorities. And one of these guys was a guy called Robert Shannon, who was a builder and had a few people working for him. And a constable came across him and his workers building a house on a Sunday. It's a shocking crime. And he found himself in the Glebe Magistrates Court. And the newspapers recorded some of the trial. And the Shannon asks the magistrate, "Will you postpone the case?" And the magistrate says, "I can't. You've practically admitted the offence. Shannon, not on the Lord's Day. I did work on the Sunday, but Sunday isn't the Sabbath, so I'm not guilty." And the magistrate says, "Well, I know what you're talking about, but that's not what the law says. We're talking about Sunday here." And the penalty was a fine of 2 shillings and 6pence, or in default, in the sense of if you don't pay the fine, you are to be publicly set in the stocks for 2 hours. That was the punishment under the statute. And Shannon said, "I would prefer the stocks to paying." And the police sergeant said, "All right, you'll find them ready for you." Slight problem. This was 1894. New South Wales had not put anybody in the stocks for decades. There were no stocks. Not to worry, the Department of Justice decided they would build some stocks and set them up on the steps of the Glebe courthouse. Bit of a public outcry, and the minister denied there were ever any plans to build some stocks. And the minister advised the governor to remit the sentence, so Shannon got off. So why am I telling you this story? What does this have to do with the Constitution and secularism? The people who went to see the Premier to get the Sunday observance laws enforced were some of the same people who tried to push to get God put in the Constitution. And the Seventh-day Adventists, the people, Robert Shannon's people, were worried that that was an attempt to allow the new federal parliament in due course to impose nationwide Sunday closing laws and enforce one particular version of Christianity on other people, including the Seventh-day Adventists. And, there was this period, at this time in the late 1800s, the 1880s, 1890s, Protestant church leaders had what a visiting Protestant church leader called a vague craving for the recognition of the authority of God. They didn't want an official established church, but they wanted their special status recognised officially. And so that manifested itself in various ways. Church leaders would lobby colonial parliaments and colonial governments for the appointment of days of prayer for the relief of drought, because as we know, prayer brings rain. Lobbying colonial politicians that public celebrations, such as the Queen's Jubilee celebrations and the Centennial International Exhibition, be opened with prayers. The opening of official things with prayers was very important to them. And the lobbying for the enforcement of Sunday closing laws, which led directly to the prosecution of Robert Shannon. And that desire for the enforcement of Sunday closing laws led to the formation of interdenominational lobby groups like the Council of Churches. And those organisations, the Council of Churches, they still exist in each state. They do different things these days, but they still exist. And in 1897, the New South Wales Council of Churches came up with a plan to petition the Constitutional Convention, which had just been convened and tasked with drafting the Constitution. And their petition had three requests. They wanted the preamble of the Constitution to recognise that God is the supreme ruler of the world and the ultimate source of all law and authority in nations. Secondly, that the new federal parliament be opened with prayers. And thirdly, that the Governor-General be appointed to set up days of prayer. And they had a couple of motives. One of their key motives, as the Seventh-day Adventists knew, was to allow federal parliament to pass Sunday closing laws. For some reason, they believed that if you mention God in the preamble, federal parliament would be able to pass nationwide Sunday closing laws. That's really bad legal reasoning, but that's what they believed. And they also wanted to give the new Australian nation a Christian character. This is that vague craving for recognition of Christianity. Their scheme for getting signatures to this petition was quite clever. They sent copies of the petition out to all Protestant ministers of religion in the colony of New South Wales and in the other colonies. And they asked the ministers of religion to get signatures either before or after the service as people wandered into the church or wandered out. And so this is what one historian's referred to as situational coercion. You're unlikely to say no to your minister as you're leaving the church or entering. The first session of the Constitutional Convention rejected the idea of putting God in the preamble. Edmund Barton, who was the leader of the convention and later the first Prime Minister, in a speech at that session said, "The whole mode of government, the whole province of the state is secular. Secular expressions should be left to secular matters, while prayer should be left to its proper place." So session 1 of the convention says no God in the preamble. God has nothing to do with what we're doing here. Church leaders were not happy. The Presbyterian leader, a guy called Rentoul, gave a speech shortly after in which he said, "Let the churches unite to see that this great blunder is not perpetuated. The churches are not going to allow a little squad of Seventh-day Adventists and other such people to run sectarianism into this great Australian Commonwealth to be. Let the churches bombard parliaments with petitions." So the churches changed tack. As well as petitioning the convention, they would now petition all of the colonial parliaments in order to indirectly pressure the convention. And they did. Lots and lots of petitions went all over the place. But meanwhile, the Council of Churches had their Put God in the Constitution petition. The Seventh-day Adventists had their own petition. Do not put God in the Constitution, and moreover, put a provision in the Constitution that says the federal parliament and the state parliaments aren't allowed to make any religious laws. And they had a whole bunch of signatures as well, and which is quite impressive for a group of only about 2,000 people. They ended up with tens of thousands of signatures. They had a couple of motives as well. First and foremost, they wanted to make sure there would be a prohibition on Australia-wide religious laws, especially Sunday closing laws, because they knew they would be on the receiving end of those laws, like their friend Robert Shannon, but also to preserve what they understood to be the Bible-mandated separation of church and state. So the mainstream Protestant leaders wanted the Constitution to reflect their vision of Christianity. And the Seventh-day Adventists, whilst advocating what we would consider to be secularism, were doing so for explicitly religious reasons. They thought the Bible required that. So this is not atheists and secularists advancing this. This is religious people for religious reasons advancing secularism. And both the Protestants and the Seventh-day Adventists were looking at similar debates that were happening in America as sort of inspiration for this. Politicians being politicians, compromise. So eventually, the politicians at the Constitutional Convention mentioned God in the preamble. So the preamble says, whereas the people of New South Wales, Victoria, South Australia, Queensland and Tasmania, humbly relying on the blessing of Almighty God, have agreed to unite in one indissoluble federal commonwealth. There was a lot of debate about the form of words, humbly relying on the blessing of Almighty God. That language, Edmund Barton said, was the least offensive form of words. The form of words that would have the least possible basis for drawing any legal implications. They had to put some mention of God in, they were subjected to enormous political pressure, and they were all politicians, and politicians will respond to political pressure. But they made sure that they chose the weakest form of words. And to make sure, so they gave the Protestant church leaders what they wanted, but also the Seventh-day Adventists and their supporters, people who worried about what putting God in the Constitution might mean, they put in a provision, section 116, which is titled Commonwealth not to legislate in respect of religion, which says, the Commonwealth shall not make any law for establishing any religion, or for imposing any religious observance, or for prohibiting the free exercise of any religion, and no religious test shall be required as a qualification for any office or public trust under the Commonwealth. And those four clauses, 3 of them are copied from America. So the US Constitution has a provision about banning establishment of religion. They have a provision about prohibiting the free exercise of religion, and they have a provision banning religious tests for public office. But what they don't have in the US Constitution is the provision about banning federal laws imposing any religious observance. The reason the Australian Constitutional Convention chucked that in was the Sunday closing issue, to make it explicitly clear that the federal parliament would not be allowed to pass religious observance laws, which is what the Protestant churches wanted them to be able to do. So there's a compromise. You can get a mention of God, but you're not getting anything else. We are not going to allow laws to impose your religion on other people. So underlying provisions of our Constitution is a vision of secularism. It's not anti-religion, because the chief supporters of it were religious. It's pro-religious freedom, but anti-religious privilege, anti-religious persecution. And Edmund Barton said in his closing speech that a concession has been made to the popular opinion that some reverential expression should be embodied in the preamble. Due care has been taken by the Convention that no reliance upon that provision and no far-fetched arguments based upon it shall lead to any infraction of religious liberty under the laws of the Commonwealth, which we hope to create. And those 2 provisions are in the Constitution today. The Protestant churches got 2 of their 3 requests. If you remember, they had 3 requests. They wanted God in the Constitution, they wanted prayers in Parliament, and they wanted the Governor-General to have national days of humiliation or prayer. They got 2. They got recognition of God, and they got parliamentary prayers. Parliamentary prayers are not in the Constitution, but in the standing orders of the federal parliament. And in 1901, when the first federal parliament met, and they decided to introduce prayers, even though lots of the colonial, now state parliaments, did not have prayers or had got rid of them, there was a reaction. The Catholic Archbishop of Melbourne objected to the form of prayer because it was the Protestant version of the Lord's Prayer. The wrong religion. And so this is one of the problems. Different people have different religions. If you're picking favourites, you're excluding people who are not members of the favoured religion. You're creating in-groups and out-groups. So at the time, the Catholics said, hang on a minute, federal parliament, you're excluding us. You're playing favourites with the other guys. You're creating us as an out-group. Then, of course, there are all the non-Christian people in the country and the non-religious people as well. A Labor Senator, Gregor McGregor, made an interesting legal argument. What did the framers of the Constitution mean? Did they mean that the Parliament was not to impose religious observances in the streets or in the schools? Did they mean that Parliament was not to impose religious observances anywhere else but here? The standing orders of Parliament command the President and the Speaker to read a prayer. That's a religious observance. So there's a legal question. Are federal parliamentary prayers unconstitutional? Section 116 says, the Commonwealth shall not make any law for imposing any religious observance. And the Senate standing orders and the House of Representatives standing orders, as I said, command the presiding officers to read a prayer. So there's two legal questions here. Do the parliamentary standing orders impose a religious observance? I think very clearly. It's a command to read a prayer. That's imposition. Imposition requires some form of compulsion or coercion, and a command to do something is clearly an imposition, and a prayer is obviously a form of religious observance. The trickier legal question is whether parliamentary standing orders are a species of law. Because Section 116, that constitutional rule, says the Commonwealth should not make any law for imposing any religious observance. So, does law mean a statute, as in something that's passed both houses of Parliament and received royal assent, which standing orders are not? Or does law have a broader meaning of simply legal rule, which standing orders are? Standing orders are binding legal rules, but they're not statutes. And that's an open question. There's no clear answer on that. No one's litigated this point. But courts have passed judgment on the validity of parliamentary standing orders in the past. So it is certainly open for a parliamentarian who would have standing to go to court and challenge this, to say, hey, court, these parliamentary standing orders are invalid, make a ruling, make a declaration that they are invalid. And I've got a picture there of the Senate president, who is an atheist, who objects to being compelled to recite a prayer from a religion that she is not a member of, but for political reasons she goes along with doing it. So there's this interesting legal question. I know we have a federal senator here, so maybe you might want to reflect upon this with your colleagues. But the question of vision for a secular Australia, which is the title of this first session of today's conference, is my point is this: secularism is not anti-religion. Secularism is pro-religious freedom. It's simply anti-religious privilege. And that vision is reflected in the text of our Constitution. And I think sometimes we forget some of the founding motivations and visions underlying the formation of this country, which I hope we'll talk about a bit more today. Thank you very much.